Unpaid internship legal? The 7-point primary beneficiary test, 2026. When is an unpaid internship legal under federal law? Courts apply the primary beneficiary test, a flexible, 7-factor analysis to determine whether the intern or the employer is the primary beneficiary of the relationship. Under the Fair Labor Standards Act, FLSA, for-profit employers must pay employees minimum wage and overtime unless an exception applies. The U.S. Department of Labor's Fact Sheet 71 outlines the test used by federal courts since Glatt versus Fox Searchlight Pictures, Second Circuit 2016. No single factor is determinative. Courts weigh all 7 together to assess the economic reality of the relationship. Factor 1. No expectation of compensation. The first factor examines whether both the intern and the employer clearly understand that there is no promise of payment for the internship. Any express or implied promise of compensation, even a future promise, suggests the intern is an employee under the FLSA. A written agreement signed before the internship begins, clearly stating its unpaid nature, is critical evidence for this factor. If the employer later provides a stipend, hourly wage, or other payment, the analysis shifts toward employee classification. Factor 2. Educational training. Like a classroom, the internship should provide training that resembles what an intern would receive in an educational environment, including clinical or hands-on instruction, structured mentoring, rotation through departments, skill-building exercises, and regular feedback all support the educational nature of the program. The key question: is the intern learning new skills or simply performing repetitive tasks that benefit the company? Internships tied to educational institutions often score well because they mirror academic training methods and curricula. Factor 3. Tied to formal education. The third factor considers whether the internship is integrated with the intern's formal educational program through coursework or academic credit. When a college or university awards academic credit for the internship, it strongly suggests the intern is the primary beneficiary. Many institutions now require internship courses with defined learning objectives, journals, and faculty evaluations to qualify for credit. An internship with no academic component, no credit, no coursework connection, leans toward employee classification. Factor 4. Accommodates academic commitments. Internships that respect the intern's academic calendar and commitments score favorably under the fourth factor. The program should not require the intern to skip classes, miss exams, or fall behind on coursework to participate. Flexible scheduling around semester breaks, exam periods, and project deadlines shows the program is designed for the intern's benefit. The DOL guidance states that the duration should correspond to academic terms or defined learning periods, not the employer's staffing needs. Factor 5. Limited duration tied to learning. The duration of the internship should be limited to the period during which the intern is gaining beneficial learning. Once the intern has acquired the intended skills and knowledge, the program should end, not continue with the intern performing routine work. Courts view open-ended or indefinite internships with suspicion, as they suggest the employer needs ongoing labor rather than providing education. A defined end date or learning-based duration cutoff, such as end of semester or completion of a project, strongly supports unpaid status. Factor 6. Work complements, not displaces. One of the most important factors. The intern's work should complement the work of paid employees rather than displace them. If the intern performs tasks that would otherwise be done by a paid employee, answering phones, filing, data entry, that is displacement favoring employee status. If the intern works alongside paid staff on projects that provide educational benefit without replacing anyone, the internship is more likely legitimate. The DOL emphasizes that significant educational benefit must accompany any productive work the intern performs for the employer. Factor 7. No entitlement to a paid job. The final factor requires both parties to understand that the internship does not entitle the intern to a paid job at its conclusion. If the employer implies or promises a paid position after the internship, the program may be reclassified as a training period for an employee. Clear written agreements, signed by both parties, stating there is no commitment to hire after the program help protect unpaid status. This factor reinforces the temporary, educational nature of the relationship and distinguishes it from paid trial employment. Summary. Applying the 7-point test correctly. The primary beneficiary test is a holistic, flexible analysis. Here's your checklist for evaluating any unpaid internship program. Document all 7 factors in writing before the internship begins, signed by both intern and employer. No single factor controls. Courts weigh all seven together to determine the economic reality of the relationship. For the full official text, visit the U.S. Department of Labor's Wage and Hour Division at dol.gov. Nonprofit and government internships follow different rules under FLSA. Consult an employment attorney for specific guidance.